Welcome to SCOTUScast, Copyright Act and Foreign Textbooks Edition. Thank you for tuning in. On June 16, 2016, the Supreme Court decided Kirtsaeng v. John Wiley & Sons. Academic textbook publisher John Wiley & Sons, Inc. owns the American copyright for textbooks and often assigns its rights to its foreign subsidiaries to publish, print, and sell its textbooks abroad. Supap Kirtsaeng, a Thai citizen who came to the United States in 1997 to study mathematics, asked friends and family in Thailand to buy the English-language versions of his textbooks in Thailand, where they were cheaper, and mail them to him. Kirtsaeng would then sell these textbooks in America, reimburse his friends and family, and make a profit. In 2008, Wiley sued Kirtsaeng for copyright infringement. He ultimately prevailed before the U.S. Supreme Court on the question whether the first sale doctrine, under which the owner of a lawfully made copy can dispose of it without permission of the copyright owner, applies to copies of copyrighted work lawfully made abroad. On remand, the U.S. Court of Appeals for the Second Circuit ruled that the first sale doctrine provided Kirtsaeng with a complete defense to Wiley's infringement claim. Kirtsaeng therefore sought an award of attorney's fees pursuant to Section 505 of the Copyright Act, which allows the award of fees to a prevailing party at the court's discretion. The federal courts of appeals have applied several different standards in resolving such fee requests. Here, the Second Circuit affirmed the denial of attorney's fees to Kirtsaeng based on the district court's view that Wiley had taken an objectively reasonable position on the underlying litigation. The U.S. Supreme Court again granted certiorari to address the following question. What is the appropriate standard for awarding attorney's fees to a prevailing party under Section 505 of the Copyright Act? By a vote of 8-0, the Supreme Court vacated the judgment of the Second Circuit and remanded the case. Justice Kagan delivered the opinion for a unanimous court, which held that 1. When deciding whether to award attorney's fees under the Copyright Act's fee-shifting provision, a district court should give substantial weight to the objective reasonableness of the losing party's position, while still taking into account all other circumstances relevant to granting fees. And 2, while the Second Circuit properly calls for district courts to give substantial weight to the reasonableness of a losing party's litigating positions, its language at times suggests that a finding of reasonableness raises a presumption against granting fees, and that goes too far in cabining the district court's analysis. To discuss the case, we have Christopher M. Newman, who is Associate Professor of Law at George Mason University's School of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Newman.
The case concerns the proper construction of Section 505 of Title 17, which provides that in a copyright action the court may award a reasonable attorney's fee to the prevailing party. Petitioner Kirtsaeng was sued by John Wiley for copyright infringement, and after losing at both the district and circuit court levels, ultimately prevailed in the Supreme Court. Kirtsaeng then moved for attorney fees under Section 505, but the district court denied the motion, and this denial was upheld by the Second Circuit. Second Circuit precedent gives substantial weight to the question whether the losing party's litigation position was objectively unreasonable, and as I'll explain in a moment, John Wiley's position in this litigation clearly was not. Kirtsaeng contended that this is the wrong standard, and that a court should award attorney's fees even against a losing party whose position is reasonable if it finds the litigation to have served the purposes of the Copyright Act. Here it's worth saying a bit more about the underlying litigation. John Wiley had sued Kirtsaeng for running an enterprise that purchased textbooks in Thailand and imported them into the U.S. for sale. Wiley argued that this violated Section 602 of the Copyright Act, which, as written, grants copyright owners the exclusive right to import copies of their works into the U.S. Kirtsaeng contended that because the copies had been lawfully made and purchased abroad, their importation was immunized under the first sale provisions of Section 109. The interplay between these two conflicting provisions presented a difficult question of statutory interpretation, both because of certain ambiguous language in the statute and because of the construction the court had given to these provisions in an earlier case. The Supreme Court ultimately held in a split 6-3 decision that first sale does apply to copies lawfully created abroad, meaning that the exclusive importation right can no longer be used to protect a strategy of price discrimination between various international markets. So there's no doubt that Wiley's position was reasonable. Nor is there any doubt that this was a very significant ruling that changed the face of copyright law. Kirtsaeng argued that this sort of a situation, in which you have a relatively small defendant persisting against all odds to achieve a result that changes the applicable law, is precisely the type of scenario in which attorneys' fees should be awarded, because you want to incentivize such defendants to keep litigating in order to achieve the end result of clarification of the law. Kirtsaeng argued that in deciding whether to award fees, a court should ask whether doing so in the particular case would advance the purposes of the Copyright Act. To decide this, the court should, according to Kirtsaeng, consider the totality of the circumstances, including the importance of the result, the relative resources of the parties, and ask itself whether, if this same scenario were to present itself again, the availability of fees would incentivize beneficial litigation. Writing for a unanimous court, Justice Kagan rejected Kirtsaeng's proposed approach as unlikely to be either workable or salutary, giving two main reasons. The first is that Kirtsaeng's approach would fail to provide an incentive structure likely to encourage the kinds of litigation he argued we should want to see. Even if you think it desirable to encourage the litigation of hard cases, making fee shifting available merely raises the stakes for both sides, each of whom risk paying not only damages but the other side's attorney's fees. This means that the incentive provided, in effect, depends entirely on the parties' respective levels of risk aversion. As Justice Kagan puts it, this means that you'll only get the result advertised if there are lots of litigants who are in the camp of people who think the higher the stakes, the greater the rush. Second, Justice Kagan pointed out that judges have no reliable way of knowing which results are the important ones that need to be incentivized. Often, neither the precedent-setting law-clarifying value of a case nor its practical impact is apparent at the moment the case is decided, and judges are not accustomed to trying to evaluate such things. The practice of giving substantial weight to the reasonableness of the losing party's position, on the other hand, looks much better on both fronts. It creates the right incentives because it raises the stakes only for parties who are advancing obviously unfounded positions, while encouraging meritorious litigants, whether plaintiffs or defendants, to resist such arguments. Further, judges are well equipped to assess the objective reasonableness of a party's position, and, contrary to the concern raised by Kirtsaeng, they should be able to distinguish between a party ultimately found to be infringing and one who raised unreasonable defenses. That said, Justice Kagan does emphasize that while it is proper to give substantial weight to the objective reasonableness of a party's legal position, it should not be given dispositive weight in all cases. Where, for example, there is litigation misconduct or repeated instances of either infringement or over-aggressive assertion of rights, a court may award fees against a party even though their position was not entirely unreasonable. Because some language in the Second Circuit case law could be construed as calling for a categorical rule, the court remanded to ensure that the district court had not made this error. The court's opinion thus leaves the Second Circuit approach fairly intact and cautions other courts against taking approaches to fee shifting that are either rigidly categorical on the one hand or based on vague, open-ended standards on the other.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.